Okay, so good afternoon, everybody. We're going to start properly now. Good afternoon, everybody. Good morning, good evening. And thank you for joining our conversation and our webinar this afternoon. We are going to look at and engage with China's new arbitration law. Those of you within arbitration, you know that a new arbitration law came into effect in China this year. And so Mr. Sun is going to walk us through the new law. We will take question and answers, questions. But what we'll do is Wei is going to speak, and he's going to speak to his slides and sort of help us understand the new law. He would do that for about 30, 35 minutes, 40 minutes. Then we would take question and answers. As usual, the webinar is being recorded, and so we presume that we have your consent
yes, of course,
to be recorded. When we finish, the recording will be uploaded onto our YouTube channel or page, and we would notify people of that, so you can rewatch it if you wish. Wei, I'm going to start by asking you to introduce yourself to us, because I just said to everybody that you are an alum, and you used to be one of my students, and that I'm very proud of that fact. So please go ahead, introduce yourself, and I'll just hand over to you so you can present and we'll take questions.
Thank you very much, Professor Emilia Onyema. It's my great honor to attend this seminar. I was as a student back 2008, 2009. Then I was the LLM students. I was Emilia's student then. I learned a lot. Before that, I was a practitioner in China. I do arbitration, litigation. Before I came to London, actually, I only learned Chinese arbitration, not international arbitration, so purely domestic practices. When I entered SOAS, I attended international arbitration course, comparative arbitration course, and I also audit Kumare's construction and arbitration. I learned a lot from that. So that's why I said that's my great honor to come back. Now I'm the managing partner of Zhonglen Law Firm, which is one of the best, I think, in China. And also I'm China's representative to Ancestral Working Group 2. You know, Ancestral Working Group 2 is commissioned to make laws and the rules under the UN framework. For example, the expedited arbitration rules, model rule, ancestral rules, all those kind of things. So I will attend. Actually, I attended Ancestral's Working Group 2's meeting every year in Austria, in America, New York. So that's the international activities that I attended. I'm also the founder of a forum. It's called Permanent Forum China Construction Law, which is platform connecting the Chinese contractors, developers, practitioners, and other experts. That's a quite useful platform, and it's my great honor that I can be the founder of that. And I got that idea when I was in the SOAS. So everything started from SOAS. So thank you very much. And now I'm going to go through the Chinese new arbitration law. So my short comment is that China's new arbitration law partially reflected the progress that Chinese arbitration practices have been made in recent years. But we still have many challenges, and we're looking forward that more progress that we can make. So that's basically the structure that I'm going to share with you. So first part would be the key amendment. What's new in the revised arbitration law? Okay, so what's new? First one is seat of arbitration. International arbitration, it's a common thing. You don't feel it's something new. But in China, seat of arbitration, this is the first time appear in law. So it was a big thing. But before the new Chinese arbitration law, the Chinese Supreme People's Court, the judicial interpretation, has already introduced. So when you want to know Chinese arbitration law and practices, you need to not only know Chinese arbitration law, but also Supreme People's Court, the judicial interpretation. So judicial interpretation try a lot of new things. Then it will be reflected by laws. That is the arrangement of legal progress in China. So you look at Article 81, that is seat of arbitration. And then look here, in the middle of the column, Supreme People's Court introduced seat of arbitration in 2008, and actually even earlier than that in leading cases. But through the judicial interpretation, that is 2008. And now, the next one is competence. Competence is the idea that I first learned in SOAS. In Chinese arbitration law, the old law is that the Chinese court of law, or arbitral tribunal, or the institution, arbitration institution, have the jurisdiction to decide whether the arbitration clause is valid or not, whether the challenge of jurisdiction should be sustained or not. But according to the new law, if one party wants to challenge the validity of arbitration agreement, the party may request arbitration institution or arbitral tribunal to make a decision, or they can apply to People's Court for ruling. So now you have an arbitration institution, you have a tribunal, you have a court. So when one party apply for the decision, from institution or tribunal, the other party resort to court. The court should have the power to make the decision. So that is the competence. And the third new thing is ad hoc arbitration. Ad hoc arbitration actually was introduced by China's Supreme People's Court. And then the newly amended arbitration law reflect this development. So if you have a look at Article 82, we actually, it's not, in China, the ad hoc arbitration cannot be used in all cases. It can only be used in foreign-related maritime matters or enterprises registered in pilot free trade zone, the Hainan Free Trade Port, or other designated areas, which means that there are only limited areas and cases that ad hoc arbitration can be used. Why? I'm the person who is not that optimistic about ad hoc arbitration in China, because we traditionally have institutional arbitration and it's functioning very well. When it comes to ad hoc arbitration, it needs arbitration tribunal very capable, and actually Chinese arbitral tribunal has been looking after by the arbitration institutions and their secretaries so well. So if you ask the arbitral tribunal to orientate themselves without support of arbitration institution, that could be challenging for them. That is ad hoc arbitration. So where actually the law is only, the ad hoc arbitration is only limited applied in China. That is the pragmatic way for Chinese arbitration community. We're going to see whether ad hoc arbitration will prosper in China. If it is, then we can use ad hoc arbitration in all cases. If not, then we will make it limited applied. And then the next thing is the contact preservation and pre-arbitration preservation measures, something similar to injunction. In Chinese litigation proceedings, you can apply in the civil proceeding, you can apply to court for injunction. Requiring the opposing party to take certain actions or refrain from taking certain actions. So that is the basic idea. It's similar to injunctions in common law system. And the other thing is that if there is some urgency, a party can apply for arbitration, can apply for injunction before you initiate arbitration. So two things. First, injunction, that can be applied before or after. Second, the application or the application if the matter is urgent, emergency. If there is an emergency, you can apply for that before you initiate arbitration. So that is the new thing in China. And there is another change, or I think it's an improvement of Chinese arbitration law, is that if one party wants to set aside arbitral award, according to the old law, you have a 6 months of period from the day when the award was made. But according to the new law, it's shortened to 3 months. Try to protect the integrity or stability of arbitral awards. And according to the Article 55, the arbitral tribunal's power of gathering evidence or collecting evidence was strengthened. International arbitration is not very common that a tribunal will collect evidence or gather evidence in a case. But in China, arbitral tribunal is it's very active in finding facts, make decision, so they have the power to collecting evidence. Another new provision reflects the development of Chinese arbitration. It's online arbitration. If you look at Article 11, so arbitration activities may be conducted online on an information network unless the parties explicitly disagree to it. Actually, from the period of COVID-19, online arbitration has been widely used. See, I give you an example that I regularly hear cases administered by Guangzhou Arbitration Commission and several others. They're far from Beijing, so I normally hear case online. It's very popular, it's convenient, and now it is reflected in the new law. And the last thing is international investment arbitration. So the Article 94 says that our Chinese arbitration institutions can administer investment arbitration. This is a purely new thing. So this is the progress that has been reflected by Chinese new law. And now I'm going to share with you what has not been reflected. The first is emergency arbitrator. So emergency arbitrator procedure, actually, in China, it has been widely adopted by leading arbitration institutions. So CTAC's 2024 rules, Beijing Arbitration Commission's 2022 rules, SHARE Arbitration 2025 rules, they are all new rules here. And you can find the old version, they have they also have the emergency arbitration rules. I am the first emergency arbitrator in China back in 2018. So 2019, I was nominated. That case was nominated as China's new development of the development of the year, arbitration development of the year. So far, I suspect that we have dozens of Chinese emergency arbitrators' decisions in China. So it's not new thing. It's gradually accepted, but the Chinese new arbitration law does not reflect that. I think the legislature take a more conservative approach on that. Early dismissal. Early dismissal is a new thing, not only in international arbitration, but also in Chinese arbitration practices. We can find the early dismissal, the relevant provision in CTAC 2024 rules, Shanghai Arbitration Commission 2025 rules, and the Xi'an Arbitration Commission 2023 rules. So that is the development in China, but that has not been reflected by Chinese new arbitration law. And then there is a gap. Gap means that what has not been done in the new arbitration law, it should have covered, it should has covered, but it failed to cover. The first is, I give you example. If you are a arbitrator, you hear a case administered by ICC, and the seat of that case is in Beijing. Okay, it's ICC case, seat in Beijing, you are the arbitrator, and one party apply for, say, injunction or preservation of a property, assets. Will the Chinese court accept this application for the preservation of assets or injunction? No. The Chinese court will not, because new Chinese arbitration law does not mention that the court should accept that kind of a case. So it's a blank, it's a gap. And also, if you look at Article 14, and it says, an arbitration institution established in accordance with Article 13 of this law shall be registered with the Justice Administrative Department of a relevant province. Autonomous regions or municipality directly under the central government. See, if a foreign arbitration institution, say ICC, LCIA, or Singapore International Arbitration Center, if they want to operate in China, if they do want to administer cases in China, should they do the registration? We don't know. If they need to do the registration, where? It keeps silent. It keeps a silence about that. So that is the gap. And then we also find that the new Chinese arbitration law says it encourages foreign arbitration institutions to conduct foreign-related arbitration in China. Yet, significant entry and operational restrictive remains arising from foreign NGO law. See, there has been, I have repeatedly been asked by international arbitration institutions, can we set up a branch in China to administer cases, organizing hearing, for example, to set up a hearing center? And I said, probably you're facing a foreign NGO law, because according to the foreign NGO law, foreign institutions, they need to establish a representative office. Look, it's not a branch, it's a representative office. In China now, mainland China now, we have Hong Kong, HKIAC, SIAC, and ICC have their own representative office, but not branch. When I say branch, it means the case hearing center, all those kind of things. They substantively involved in case management, not just representative to do the network building, to do the promotion. So their activity, the representative office activity, are limited to promotion and client development. They are not permitted to administer cases or conduct hearing in China. And then the representative office must have a pre-planned annual activities and file year-end report. Any off-site event requires separate local filing. And the funding is restricted to overseas sources. No profit making, no sponsorships. So that is the problem. So the way forward, I believe we need to relax NGO laws application to foreign arbitration institution. And we should expressly permit branches, not just representative office. And we should allow substantive arbitration activities, for example, case management, hearing, all those kind of things. Simple filing procedure, ease funding restrictions, and permit reasonable sponsorship. So that is my expectation. And looking ahead, we're expecting that in the future we're going to have another amendment of the Chinese arbitration law. So if we make some anticipation, what that kind of a law should be like. So I strongly support we should have a dual-track arbitration regime. That means that we have a Chinese domestic arbitration law, and we have international arbitration law. When it comes to international arbitration law, I mean for example, the model law. That would be most easy thing. We just take the model law to do the international to govern the international arbitration. Chinese domestic law governs the Chinese purely domestic arbitration cases. Because the Chinese domestic arbitration and international arbitration are under different philosophies, and they have a different needs. So when I began the seminar, I said before I came to SOAS, I only know Chinese domestic arbitration practices. I only know Chinese arbitration law. I don't know international arbitration law. When I studied international arbitration law, I realized there's a huge difference. I'm going to let you know how different they are. So first, the Chinese domestic arbitration. So the arbitration institutions is quasi-government characters. For example, arbitration institutions established by government and by government, and also the normally the leaders of the arbitration institutions should be appointed by government. Of course, they are very professional, but they are appointed by government. And the Chinese arbitration emphasize on substantive justice and social stability. So I give you an example. So in China, mediation is very popular. So arbitral tribunal-led arbitration mediation is a practice. It's very common in China. The purpose of that is to solve the problem in an efficient way, and is widely accepted. And also in China, see, if you are arbitrator in an international case, the claimant's request that the respondent should pay liquidated damages because they breached the contract, and you found that the contract could be invalid. What should you do? I think normally the International Arbitration Tribunal will remain silent. They will not say, look, what about if this contract is invalid? But if in China, in domestic cases, the arbitration tribunal will actively participate in the hearing case. They will ask, what if the contract is invalid? Are you going to amend your request for arbitration? Why they do that? Because they want to solve the problem in a more efficient way rather than just kick them back. They use 10 months, 1 year to finish the case. Say you're making mistake because the contract is invalid. Your basis for breach of contract is not that solid. So this is what we call is the tribunal-led clarification. And also, I mentioned that arbitral tribunal in China, they have the power to collect evidence that is very common as well. And before we have a Chinese arbitration law, it's a new thing. It's in 1950s. Quite late. Before we have a Chinese arbitration law. The civil procedure law governs in people's, when we have new Chinese arbitration, when we made Chinese arbitration law, we adopt a lot of ideas and provisions. We transplant that from civil procedure law. So if you look at the Chinese arbitration law, you can find a lot of similarities from civil procedure law. That is what we call is judicialization of the procedure. And it's not like the international arbitration. And also institutional-led model, which means that, for example, if you are going to be appointed in a domestic case, you must be arbitrator in the panel. If you're not a panel arbitrator, you cannot be appointed. In a case management, arbitration institutions and case secretary closely follow the case. They will be very capable very helpful. So it reflects the institutional-led model. It's different from international arbitration. So these features have served domestic dispute resolution very well. It makes the Chinese arbitration efficient, very efficient and cost-effective. So every year, if you look at the statistics of arbitration institutions, leading arbitration institutions, you'll find their business is booming because people gradually realize the usefulness or the benefits of domestic arbitration. But now, if you look at the big picture, so China has already deepening in the global economic engagement. China is the second largest economic entity in the world. Chinese investors do the investment across the world. So Chinese leading arbitration institutions moving ahead of Chinese arbitration law and the Chinese arbitration practices. They adopt a lot of new things. They borrow that or they learn that from international arbitration institutions. And then we find that more and more Chinese arbitration institutions are dealing with international or administer international cases. And Chinese arbitrators are becoming more and more capable in dealing with international matters. So look, on the one hand, we have a Chinese domestic arbitration development, very positive, very positive way. It's very China-specific way. And then you see that we're seeing increasingly international cases, increasing international case load. The needs are different, the philosophy are different. So if you want to balance the two, the international and domestic arbitration cases, look after them, you need to have a dual arbitration law, domestic arbitration law, and international one. So if you do comparative study, Singapore once has International Arbitration Act and Arbitration Act. That's the dual arbitration law arrangement. And Hong Kong, as a jurisdiction, they have the similar arrangement. And with the development of domestic arbitration, then they gradually united the laws. So that is, to sum up, we have the Chinese new arbitration law partially reflect the development of Chinese arbitration practices, and there are some gaps which we need to do in further, and we find that there are some clash or inconsistency between the law. For example, how foreign arbitration institutions do their business in China. And if we look forward, we're expecting that we can have a dual law system, arbitration law system. That is basically what I need to share with you. Hopefully that you can have some questions that I can share further with you all.
Thank you so very much. Okay, great. We have two questions already in the chat.
Yes.
But I'm going to kick off. You already summarized, so I don't need to summarize your presentation again because you've summarized. So hopefully, and I was putting stuff in the chat, so hopefully that would help trigger people's memories. Let me start with the last point you made, which is this whole idea of a dual track, or one for international and one for domestic. And going back to the historical development of arbitration in China, I was just wondering if the Singapore system is the right one for China. And this is in relation to the level of economic growth and the type of economic activity which feeds into the first question that we have, the type of economic activity and the numbers, the sheer, caseload of the arbitration centers. So I was just wondering whether retaining a unitary system, a one law system, may work better for China. I was wondering if you have challenged your idea of a dual system, a two-track system.
See, in China, the Chinese people are very used to the cupping therapy, but it's not that comfortable for foreigners. Actually, same theory. In China, domestic arbitration, I'm giving a number, we have several 100,000 cases every year, domestic arbitration. For international arbitration, it's only a small portion. But if you give the number, the number is quite big. But compared to domestic arbitration, it's a small. So we cannot bend the international arbitration's rules or practices to feed the Chinese domestic arbitration. And we cannot, of course, conform the Chinese arbitration, domestic arbitration, into the international ones, because it's long, it's quite expensive, and it might not feed the Chinese people the theory. For example, we're expecting that the arbitral tribunal can do some mediation. See, you are the boss. You decide the case. You let us know what should we settle the case. And we're expecting that the tribunal can give some suggestions. So we accept that. And around 30 or more than 20% of the cases were settled every year by mediation. And the people are quite fine with that. But in international arbitration, it's not accepted because you cannot have double heads.
That's really interesting. So I suppose for those who are more interested in, as long as the dispute settles, let's get on with it. Yes. They may have a different view. Before I ask Mark to speak, I want to read out the question from Dr. McLuve, Amel McLuve, who is one of our management committee members, and she's a practitioner out of Paris, and she's from Algeria. Yeah. And so she says, as an Algerian citizen, I would be interested to know whether there are increasingly more arbitrations involving Chinese and not African parties, particularly Algeria. And so Amel, the answer is yes. And whether these arbitrations are often seated in China, given the significant growth in trade between China and Algeria. So do you guys force the Algerians to fly all the way to China for the arbitrations?
It depends. Actually, depends on the negotiation power between the parties. If Chinese party are power enough, they will try to use Chinese arbitration institution, or they may, as a compromise, they may use Hong Kong as a seat of arbitration. There are several Chinese leading arbitration institutions set their branches in Hong Kong. For example, CTAC, SHIAC, and the Shenzhen Court of International Arbitration. They are all very good. The Hong Kong courts are very efficient. So it's widely accepted that this is a very popular seat of arbitration. And also, we find more and more foreign parties to participate in Chinese arbitration. Not only the African parties, but across the world. And also, we're seeing more and more interesting cases. Is that, say, I give you an example, that Chinese main contractor or Chinese general contractor, they build a thing, in African country, and then Chinese subcontractor do work for the general contractor, main contractor. If they have a dispute, Traditionally, they use the local courts in the project. Now they come back to China to use Chinese arbitration institution to solve their dispute. So we're seeing more and more the Chinese arbitration have become more and more attractive. I heard many cases, these foreign related cases, say the project is overseas, but the parties are Chinese and also the foreign parties. And if they have any problem, they come to China just online. It'll be cheaper. You file online. I give you an example. If you use SHIAC, Shanghai International Arbitration Center, you file cases online. They will only charge you 80% of the cases of the fee. It's much cheaper. Then you come to China to file the case. So they promote e-filing. You don't need to come to China. Everything is quite efficient.
Which is really interesting, which begs the question whether Chinese businesses are willing to also have institutions in their counterparts country, host those arbitrations. So, for example, just going back to Amel's question, if the dispute is between a Chinese main contractor and an Algerian employer,
yeah.
would the Chinese party, for example, be willing for the arbitration to be hosted in Algeria, knowing that they can also do online filing and online hearings?
It's actually it's not rare that Chinese contractor use the employer jurisdictions arbitration institution. It's quite formal. It's quite common. It's quite common. And there's another. You're seeing the businesses booming in Singapore is because that the Chinese employer, the Chinese contractor cannot agree to use the employer jurisdiction institution. Then they use the third jurisdiction, the neutral one. The most popular one will be Hong Kong, Singapore, and Hong Kong.
Yes, I was wondering when you're going to mention Singapore. Now that you've mentioned Singapore, Mr. Tan, Ashton Tan, who works at Maxwell Chambers, will be very pleased. Mark, and then I would go to another question in the chat. Mark,
yes,
please.
Mark.
All right, thank you so much, Professor. As always, thank you, Mr. Sun, for that very insightful presentation. And I'm happy to share with you that we both are part of SOAS together. I'm also soon to be a SOAS alumni, actually. So thank you for that, and it's good to hear all the progress you've made, especially in China. It's very inspirational. As it relates to the presentation, I just wanted to sort of engage with you on this idea of court supervision or court interference as it relates to the new Chinese Arbitration Act. And if we look, I was actually very fascinated, if we look at, for example, Article 31, which you were discussing, which sort of brings in competence into the Chinese Arbitration Act. But if we interrogate it a bit further, it's questionable as to whether there's truly competence, whether the arbitral tribunal truly has the competence to rule in its own jurisdiction, because obviously if another party decides to go to the court, then the court will have precedent over the ruling in that matter. And so I just wanted to ask you, moving on or looking into the future, do you see, especially as it relates to the domestic arbitration matters, do you see changes in the arbitration law that would allow for more autonomy of the tribunal and potentially less interference of the courts? And also just touching on that, I know obviously you've also talked about the idea of having a dual arbitration framework, which would then allow for an international spectrum to be, to have less interference, or to have provisions where really the court isn't interfering as much with the arbitration. And if that were to happen, wouldn't it be the case that the provisions, or really what would happen is in the international provisions, or in the provisions relating to the International Act, there would be supportive or maybe support more autonomous decisions of the tribunal or less interference of the courts, whereas in the Domestic Act, it would then sort of leave provisions that allow the court to interfere in decisions the tribunal is making. And really, even if we look at this current act, for example, if I just give you a quick example before setting down, if we look at the provision as it relates to the setting aside of an arbitral award, under Chapter 5 and Article 71, sub-Article 5, it allows the court to set aside an award if the opposing party concealed evidence that would have affected the fairness of the award, which sort of allows the court to investigate what's already been before the tribunal. And if we go to the provision, the special provisions on foreign-related arbitration under Chapter 7, we find under Article 83, in setting aside an international arbitral award, this ground isn't included, which is sort of lays to us that, they're cognizant of not interfering with international arbitral awards. So in that case, if we're to have the dual system, and I know you compared it to Singapore, but, if you look at Singapore, even if we compare the two acts, in my view, the Domestic Act isn't or doesn't include provisions that allow for court interference to the extent that this current act in China does. And I would sort of maybe compare it more to the South African dual arbitration laws, with obviously the domestic law in South Africa being from 1965, obviously taking the 1950s English Arbitration Act, which emphasized at that point a lot of court intervention. So in that case, would it then push more intervention towards domestic arbitration? And finally, as you were talking and you were summarizing, you were saying that as it relates to domestic arbitration, the current law is actually helping and practitioners like yourself in China feel comfortable with the current act as set out. So is it a case where actually, in China, you've sort of embraced, from the basis of your history, you've embraced more court intervention in arbitral related matters at a domestic level, which would obviously interfere with it from an international perspective, hence the dueling of the two acts.
Okay, it's a very good question. It's a very good question. See, first, the competence. Why we need competence in international arbitration? Because ad hoc arbitration is quite popular. But if there is institutional arbitration, do we really need competence? Not necessarily. See, if you look at ICC's arbitration rules, in certain circumstances, that ICC has the right to decide on the jurisdiction. So why not just left that to entire the jurisdictional matter in the arbitral tribunal's hands? Because they can identify, they can decide, right? That'll be easy for them to solve this problem at the early stage, rather than spend a lot of money appointing arbitrator, spend money, and solve the problem at a later stage. So see, if it's a ad hoc arbitration, you need to have some entity to decide the jurisdiction. So who? It must be tribunal. So that is the necessity of a competence. Now come back to China. Arbitration institutions has very extensive experience in dealing cases. They are very careful that if they administer a case, but they do not have jurisdiction or the arbitration clause is invalid, what is going to happen? The case will be the award will be set aside or will not be recognized, will not be enforced. So that will damage their reputation. So they are very careful. They are very capable. So it'll be good for arbitration institution to deal with that. Of course, in certain circumstances, it'll be if you do not hear the case, you cannot understand or you cannot make a decision whether you have a valid arbitration arbitration agreement or whether the jurisdiction challenge is valid or not, then the arbitration institution will designate a tribunal to make a decision. So that's the arrangement. So come back to court. Chinese court, I'm not seeing it's an intervention. I call it a Chinese court support or supervision. Why? Because when the Chinese court, I assure you, Chinese court do not want to hear the case at all because they get their hands full, extremely busy. If the party wants to use the arbitral institution or the tribunal to solve their problem, that'll be extremely happy. If they hear the case, they'll be very supportive. I give you an example. If I'm a party based in Beijing, and the other party is based in Shanghai, according to Chinese judicial interpretations, if, say, the court in Beijing said this arbitration agreement is invalid, what the court do? They need to report that to Supreme Court. See, you are a judge. Do you want to report that to Supreme Court? No, of course not. Yeah. Why Chinese judicial interpretation makes such a supervision? Because they do not want to intervene arbitration, but they want to supervise. So what they give is a support rather than it's not a intervene. And then another good example is that if you look at the cases, the recognition enforcement of foreign arbitral award, if any courts want to refuse to recognize or refuse to enforce, they need to support the Supreme Court. Until the Supreme Court gave their decision, you cannot make any decision. So it's really, really difficult in China to refuse a foreign arbitral award. So that is the Chinese court attitude, to support rather than to interfere. And then you can find that domestic arbitration, why we have the difference. See, if one party conceal evidence and that will make substantial, make the case, will cause the in that circumstance, the court have the power to set aside arbitral award. So if you look at how many arbitration institutions we have in China, we have more than 280 arbitration institutions. How many we have? Oh, we have several 100,000 cases. We have a professional, we have a very professional traditionals. Of course, sometimes we have not that professionals. So you need to Chinese court to supervise, to make sure that you are making good awards. See, if you come back to the to my slides, we see that Chinese domestic arbitration pay a lot of attention to substantive justice. That is the substantive justice, to make sure that every party need to participate the arbitration in a proper way. You cannot conceal evidence. So it's called a suppress evidence. So that's the logic behind that.
Thank you very much, Wei. Can I quickly read out the last question? And if you give us a very short answer, because we're quickly running out of time. So we have a question from Mawish Elahi, and they said, so in relation to domestic arbitration in China, whether you're referring to Amended, is that in vogue? Do people like the idea of you commence an arbitration, then you do mediation, then you go back to arbitration?
Yes, it's quite popular. I said that 30%, around 30% of cases were settled by arbitration, mediation, and arbitration. So that's common practice.
Thank you very much. Thank you. So I think we've had a fascinating discussion. There's lots left that we can carry on talking about. I'm going to ask my colleague, Hussein Hari, our professor of practice here at SOAS, Hussein Hari KC, who's also a member of our management committee, to close us out, to thank Wei for us. Hussein, please.
Thank you.
Thank you, Emilia, Professor Onyema, and thank you very much, Mr. Sun, for your really excellent presentation. I think you gave us a lot. We got a lot of insights into specific developments with the amendment to the Arbitration Act, issues like seat and competence. But I think more broadly, you also helped us to understand some of the particular features of the arbitration landscape in China, in particular the institution-led model, the importance of the institutions and issues that would ordinarily, perhaps in other jurisdictions, be considered for the tribunal, and also the direction of travel in terms of potentially the dual track that you outlined along the lines of Singapore, as China increasingly has more and more arbitrations of a particular international nature that perhaps don't lend themselves as well to some of the local features, such as arbitrators, playing the role of mediation and so on. So I think it was a very rich talk in terms of the developments, the changes, and the direction of travel. So thank you so much for that. We're all very grateful and very much appreciate you, not least as a SOAS alum coming back to us and giving us this talk from the top of practice in Beijing. So thank you very much.
Thank you very much.
Oh, okay. Thank you very much, Hussein.
Thank you, Emilia.
Thank you, Wei. Maui says I'm also a SOAS alum from 2003 and a practicing litigator and mediator from Pakistan. Thank you, and that's very nice. Hussein, we're making waves, so we're moving forward. Thank you so very much, everybody. Thank you, and bye.
Thank you. You have a good day. Bye-bye.
Thank you very much.